started my career as a lawyer, and I was working for a law firm, and I got loaned out to work for GE. This is in the early 90s. And at that time, the big priorities at GE, major push, were on consolidating their number of law firm vendors from 500 down to a manageable number, putting alternative fee arrangements in place, building in-house capabilities much stronger, and putting their legal work through RFPs. Well, now, as part of my job, I like to make it a standard practice to go around and meet with customers and clients. And so I happened to have lunch a few months ago with in-house counselor from GE, and I said, well, what are your key priorities? Consolidating our law firm vendor base from 500 down to a manageable number, putting our work through RFPs, pushing our, and it's clear it can't be a push. It's got to be a collaboration. I mean, this is not going to be driven or pushed by one side or the other. I just the law firm institutions themselves are too difficult to change institutionally, and I don't think it can be pushed by corporate counsel alone. I think it's got to be a dialogue. Rich, how we get there, who knows?
Look, I do not believe that alternate fee arrangements are the panacea that they're being written about and extolled around the country. We've done them. We did them many years ago. And maybe it's the thin air in Denver, I'm not sure what. But they have been a colossal train wreck for us. And really the challenge has come to follow up on Tom's point, how you truly measure value. How you measure the value that our outside firms or our inside lawyers actually deliver. And we, unfortunately, I think as a profession, take the obscenity approach, that we know value when we see it, and that's how we measure it. And there is data that is there. There's data that is available to us through advances in technology that is going to allow us, I believe, to assess truly the value and to be able to compare Pete's firm versus Martin's firm versus a third firm in real, truly meaningful ways. But until we get there, at least for us, we can't get our arms around a fixed fee or other alternative fee arrangement.
I was just going to follow up on what Rich said, and I've already asked them before this began that as soon as they get there, they can let me know how to do that, because the data on value is extremely hard. We have data on results is one thing, but data on value is differently. I think the alternative fee arrangement, and there are lots of different definitions. I was at one of these things where one managing partner of a law firm said, well, we consider an alternative fee arrangement to be anything other than our standard hourly rates. And so I couldn't resist and said, well, on that basis, 98% of our work is done on an alternative fee basis. But the ones that work, without going into undue detail on the 90-second rule here, is that it require a lot of trust between the law firm and the client, and that trust builds up over a period of time. There are very good things about that trust for both sides. That trust creates a huge barrier to entry for other law firms for the client, and that is something that the clients have to think through. If you've got half a dozen law firms that have 60% of your 70% of your work because you've developed these kinds of relationships over time, it becomes a lot harder for another law firm to break in. So there are pluses and minuses on it, and you have to prepare your management to understand that when you have some kinds of alternative fee arrangements, like contingency arrangements, that sometimes you're going to pay people vastly more than they would have received on an hourly basis. And as far as I'm concerned, that's just fine. If we're making rational and sensible business decisions about contingencies, and we pay somebody $50 million, because we recover $1 billion, or because we don't have to pay $1 billion, that's fine with me. And the business people will tell you that's fine with them until it comes time to write the check. Right. And so for both sides have to understand the pluses and minuses. But I think this is, to answer the question, I think it is a long-term trend. It may be back to the future, right, before the hourly rate was invented. But I think that you're going to see more and more done on, some kinds of work has to be done on an hourly basis for a variety of reasons. But I think you're going to see more and more done off the hour.
Bill?
I think that the period we're going through now is a period of tremendous disruption, and on the one hand, the old model is going away, and we should be wiping our eyes in tears because a lot of us flourished under that. But by the same token, some group is going to make a ton of money from this transition. That's one. But the second point I want to make builds on what Michael said. He already said trust is a barrier to entry. Trying to communicate to my students, and I spend a lot of time doing this, our whole first year curriculum is based on this, is the idea, look, if you can get somebody's trust in a business context, you'll make a living for a life. And trying to convince law students that it's not how smart you are, well, that's a pay-to-play thing, but it's building that relationship and trust. That's a real paradigm shift for law schools, and we're really focusing on that. That's key.
There is a development in the corporate world. Again, I want to be, I think I'm probably overstating it, but I've observed in some environments a development that is quite antithetical to trust building up, and that is the insinuation of the procurement function into the retention and pricing for law firms, oftentimes with the same people who are comparing toilet paper vendors will be driving decisions. Now, Martin and I are put in an awkward position on these panels because there's, at some level, an irresistible tendency to ingratiate ourselves to the clients on the panel. And
you seem to be not at all concerned.
I just wanted to make sure my credentials are in order and that what I'm about to say doesn't sound like ingratiation. And but several years ago, I mean, so I could say it predated this panel. I wrote an article for one of the 10,000 American lawyer publications, like a corporate some corporate something or other, and called The Critical Crossroads of Corporate America. And it was the general counsel function. And so I hear you talk about data being available to measure value, and Michael says, yeah, maybe, maybe not. To me, it's a question of judgment by the general counsel function, and often the general counsel, about which law firms and which lawyers are adding value in his or her experience, value to the shareholders of the enterprise, and that whole process is undercut by insinuating procurement functions into the process. And to the extent the legal function, this critical crossroads of corporate America, especially in the post-Sarbanes-Oxley world and in light of all that's happened in the last couple of years and the further intrusions into the private markets, to undermine the general counsel function, to me, will result in a further erosion of trust with law firms. It will not result in value add for the shareholders of the enterprise, but quite the opposite.